If a new director is appointed during the year outside of the shareholder meeting context, a Form 8K must be filed under Item 502D with some but not quite all of the disclosures that will eventually be made in the next proxy statement about the director. Today on Zippy Point. I'm Brock Romanek, and I'm a big fan of U's. So when companies have a vacancy on their board, they're typically not in a rush to fill that open seat. It's common to wait until the next annual shareholders meeting because that will allow for the natural recruitment process. Someone will have to be recruited to be on the board, to be part of the slate of nominees voted upon by shareholders in the normal course. For these normal course additions of new directors, the company doesn't have to file an 8K. It's just part of the proxy statement disclosure that shareholders are made aware of this new nominee. But sometimes a new director will be appointed during the year between the annual shareholders meetings, and technically most bylaws state that this appointment is really an election, even though it's just an appointment, even because the board votes rather than shareholders on this appointment. Got it? So the board must follow the procedures required by the company's bylaws to accomplish this appointment. Thus, the board controls the timing for when this appointment occurs. Then that new director would be placed on the ballot for election at the next shareholders meeting. So you have an appointment during the middle of the year, before the annual meeting, and then they're part of the slate for the next annual meeting. If a director is appointed outside of the shareholder meeting process, a Form 8K was required to be filed, and Item 502D of Form 8K requires these 5 things in that 8K. 1, the new director's name and the date of the appointment. This date literally is when the director is appointed by the board, not the date on which the director goes to their first board meeting. As noted in this CorpFin staff interpretation, this appointment date is important because it's the triggering date for when the 8K is required to be filed within 4 business days of the appointment date. 2, a brief description of any arrangement pursuant to which the director was selected as the director. This typically would come into play if the director was stockholder nominated. If it's a controlled company, there's a large shareholder that has the power to place someone on the board, or maybe it's a creditor, there's a big loan agreement. So maybe the new director was added as part of a financing transaction. 3, the new director's board committees, the board committees to which they know they've already been assigned as of the date of the filing of the 8K. 4, information required by Item 404A, can I do an A? Of Regulation SK, related party transactions with the company. 5, brief description of any material arrangement to which the director is a party. This elicits disclosure about how much the director will get paid for that new director gig. Typically, the new director's compensation will be the same as the other directors, and that information is pretty easy to find and included, right? And as noted in this CorpFin staff interpretation, that allows you to just cross-reference the formula if there's a certain formula by which all the directors get paid, if they all get paid the same amount. Now, if the new director's compensation arrangement is not the norm, there's some kind of deviance from what other directors are getting paid, you're going to need to describe those unique details in the Form 8K. Now note, the new director does not have to sign this 8K. The signatory is an officer who is authorized to file these current reports, these Form 8Ks with the SEC. And here's a few tips about possibly delaying an appointment until you have the new director completely fill out a D&O questionnaire so you have all the information you need to file the 8K. Part of that might be which board committees you want the new director to sit on. And if you don't know which committees the director will serve on, or you don't know the related party transaction stuff yet at the time you file the new 8K, you're going to have to amend that Form 8K when you find out that information. So the key here is to know this stuff before you appoint the director if you can, and that way you don't have to hassle amending the 8K. But amending the 8K is not hard to do, so if you need to do it, you do it. But amendments do happen all the time, particularly for committee assignments, since that sometimes take a little while to figure out which committees this new director will best fit on. So here's an example of an amendment to a Form 8K to add 2 committee assignments for a new director. When you file the amendment, on the cover, the date of the report is the day you filed the amendment, and then in parens, you disclose the date you appointed the director, not the date of the filing of the original 8K. This is for an amendment. And in this case, note that this amendment is filed nearly 6 months after the original appointment. That's an unusually long lag time to make a committee assignment, but it happened. Typically, the committee assignments happen pretty soon after the new director joins the board, within a month or two when the first board meeting happens for that new director. This Corp Fin staff interpretation clarifies that there's no requirement to amend the 8K announcing the appointment of a new director or file a new 8K if the director's committee assignments change a few months later, so long as the change in assignments wasn't contemplated at the time of the director's initial election to the board, initial appointment to the board. And so if there's a change in situation and the board committee assignments change, as long as it's after the fact and not contemplated, you don't have to bother amending the 8K. And then the same considerations apply about the stock ownership of the new director. How many shares of stock in the company that the director just joined do they own? Sometimes you want to delay the appointment of this new director until you know this stuff, because you're going to need to file a Form 3, a Section 16 filing within 10 days of the appointment of that director to disclose their stock ownership. You also need to have Edgar codes for this new director, perhaps, to file the Form 3 if they already don't have Edgar codes. And I have a separate Vid-Guide about how you get new Edgar codes for a new director. So let's go through two examples. In this example, there's an amendment with an explanatory note. Explanatory notes are permitted and are a good idea if you think the reader might need help understanding what you're doing. This amendment rehashes the stuff that was disclosed in the original 8K. That's not required, but it's helpful to make the reader understand what's going on. They don't have to go digging into past filings to figure it out. Most of these 8Ks for new directors include biographical information, even though that's not required. It lets shareholders, it lets investors know who this new director is. If the director will be deemed independent under the company's stock exchange listing standards, that typically is voluntarily disclosed too, because it's a big deal for shareholders, for investors to know that, particularly if they're going to serve on some key board committees, that it will be required that they be independent. The second and fourth items I mentioned above typically don't elicit any disclosure. There's nothing there, even though it's not required. Most companies then decide to go ahead and provide disclosure, what I call negative disclosure, saying that there isn't any arrangement with the company nor any related party transactions, as a way to let shareholders, investors know, and the SEC know that the company was aware of this disclosure requirement, but that there is nothing to disclose. And then here you have an example of an 8K that references the proxy statement for disclosure about director compensation, as well as the fact that the director has entered into an indemnification agreement. That's a common agreement that new directors enter into. They get some protection. If you know me, I'm all about usability. This example from eHealth is mostly in one paragraph and it's hard to read, but that's allowed. It does have biographical information. There are no committee assignments yet. An amendment is filed for that 6 weeks later. It has a negative disclosure about arrangements and related party dealings. And it has the director compensation disclosure here in a separate paragraph. No reference to the proxy is made. So maybe this compensation arrangement is unique, but maybe it's not. You would have to go and read the proxy to figure that out. And let me know what you think.